I was standing in my driveway on a perfectly ordinary Tuesday morning in June 2024 when I noticed the bright orange envelope tucked under my windshield wiper, and something about the aggressive color told me my peaceful life in Scottsdale, Arizona was about to get a whole lot more complicated. The envelope had "Violation Notice" stamped across it in bold red letters. I pulled it out and scanned the contents, my coffee growing cold in my other hand. According to the Saguaro Heights Homeowners Association, I was being fined $500 for parking a commercial vehicle in my driveway. I looked at my Toyota Tacoma, the same truck I'd been parking in the same spot for the 3 years since I bought this house. It was not a commercial vehicle. It was a regular pickup truck that thousands of people drove every single day. I went inside and called the number listed on the notice. A woman answered on the third ring with a clipped nasal voice that immediately set my teeth on edge. "Saguaro Heights HOA, this is Brenda speaking." "Hi, my name is Mike Carson. I just received a violation notice about my truck, and I think there has been a mistake. I drive a personal pickup truck, not a commercial vehicle." "Mr. Carson, let me pull up your file," I heard typing in the background. "Yes, here it is. The violation stands. According to our revised community guidelines, any vehicle with an open bed or cargo capacity exceeding 6 feet is classified as a commercial vehicle and cannot be parked in a resident's driveway overnight." I felt my jaw tighten. That rule did not exist when I bought this house. I reviewed all the HOA documents before closing. The board has the authority to update and revise rules as needed for the betterment of the community. The new guidelines were approved at our April meeting and went into effect May 1st. You should have received notification in the mail. I had received no such notification, but arguing with Brenda was clearly going nowhere. "Can I speak to someone on the board about this?" "You can submit a written appeal to the board, and they will review it at next month's meeting. In the meantime, the fine stands, and you will be assessed an additional $200 for each week the violation continues." She hung up before I could respond. I stood there holding my phone, anger bubbling up in my chest. This was insane. My neighborhood was full of pickup trucks. I looked out my window and counted 4 just on my street alone. Were they all getting fined too? I spent the rest of the morning knocking on doors. My neighbor directly across the street, Tom, also drove a truck. He had not received any notice. Neither had the Johnsons 3 houses down, who owned a Chevy Silverado even larger than my Tacoma. I walked the entire neighborhood, and out of 11 pickup truck owners, I was the only one who had received a violation notice. That evening, I pulled out every document from my home purchase. The HOA bylaws, the CC and RS, or covenants, conditions, and restrictions, every piece of paper my real estate agent had given me. I read through them carefully. There was nothing about commercial vehicles. The parking rules were straightforward, stating that residents could park personal vehicles in their driveways and that no inoperable vehicles or RVs could be stored in visible areas. That was it. The next day, I drafted a formal appeal letter. I cited the exact language from the original bylaws, noted that my truck was a personal vehicle, and pointed out that numerous other residents had similar vehicles without any violations. I drove to the HOA management office, a small suite in a strip mall on Shea Boulevard, and hand-delivered my appeal. Brenda was sitting at the front desk, a woman in her late 40s with severely cut blonde hair and thin lips that seemed designed for frowning. She looked at me over her reading glasses with obvious annoyance. "I am here to submit my appeal," I said, placing the envelope on her desk. She took it without looking at me. "It will be reviewed at the next board meeting on July 15th. That is 6 weeks away. The notice said I would be fined an additional $200 per week. Then I suggest you move your commercial vehicle to comply with the regulations." "It is not a commercial vehicle. It is my personal truck. The board has defined it as such in the revised guidelines." Her tone was flat, final. "Can I at least see these revised guidelines? I never received them." She sighed heavily, as though I was asking her to move a mountain. She turned to her computer and clicked around for a moment before printing out a document. She handed it to me without a word. I read through it right there in the office. The document was dated April 20th and supposedly contained the new community guidelines. The section on vehicles was completely rewritten. Not only did it classify any truck with a bed longer than 6 feet as commercial, it also banned boats, trailers, motorcycles, and any vehicle with business logos or lettering. The rules about lawn maintenance had been changed too, requiring that grass be cut weekly and that only specific types of decorative rocks be used in landscaping. There were new rules about fence heights, mailbox designs, and even what colors residents could paint their front doors. "This is completely different from the original bylaws," I said. "The board has the authority to update community standards." "Do they have the authority to target specific residents? Because I am the only person on my street who received a violation, and there are multiple trucks just like mine." Brenda's expression did not change. "Violations are reported and investigated on a case-by-case basis. If you believe other residents are in violation, you are welcome to file a complaint." I left the office feeling like I had just argued with a brick wall. Something about this whole situation felt wrong. It was not just the arbitrary rule change or the selective enforcement. It was the timing. I tried to think if I had done anything to upset anyone on the board. Then it hit me. 2 months ago, in April, there had been a community meeting about installing speed bumps throughout the neighborhood. The board had been pushing for it, claiming it would make the streets safer for children. I had attended the meeting and spoken against it, arguing that our neighborhood already had very little traffic and that speed bumps would be an unnecessary expense that would increase our HOA fees. Several other residents had agreed with me, and the motion had been voted down. The board president, a woman named Patricia Holbrook, had looked furious when the results were announced. She had made a comment about how some residents did not care about the safety of children, looking directly at me when she said it. At the time, I had shrugged it off. Now, I wondered if that had made me a target. I decided I needed legal advice. I found an attorney who specialized in HOA disputes, a man named David Chen, who had a small practice in downtown Scottsdale. His office was on the 3rd floor of an old building with a view of the McDowell Mountains. He was in his mid-30s, sharp-eyed and intense, with the air of someone who genuinely enjoyed a good fight. "Tell me everything," he said after I sat down. I walked him through the entire situation, from the violation notice to my conversation with Brenda to the suspiciously targeted enforcement. He took notes and asked pointed questions. When I finished, he leaned back in his chair. "This is not uncommon, unfortunately. HOA boards sometimes abuse their authority to harass residents they have personal issues with. The good news is that there are legal protections against this kind of selective enforcement. The bad news is that fighting an HOA can be expensive and time-consuming." What are my options? First, we need to get copies of all the official HOA documents, not just what they give residents, but everything on file with the county. Bylaws, amendments, board meeting minutes, financial records. If they change the rules, there should be a paper trail showing how it was done and whether it was done legally. What makes a rule change legal or illegal? HOA bylaws typically require specific procedures for amendments. The board usually has to provide advance notice to all residents, hold a vote, and sometimes get approval from a certain percentage of homeowners. If they did not follow their own procedures, the rule change could be invalid. Also, even if they followed procedure, they cannot selectively enforce rules. If they are fining you for your truck but ignoring identical violations by other residents, that is discrimination, and it is actionable. David sent a formal records request to the HOA that afternoon. Arizona law required them to provide copies of official documents to homeowners within 10 business days. We settled in to wait. Meanwhile, the fines kept coming. Every Tuesday, like clockwork, another orange envelope appeared on my windshield. $500 for the initial violation, then $200 for each week it continued. By the end of June, according to the HOA, I owed $1,500. I refused to pay. I also refused to move my truck. This was my home, my property, and I was not going to be bullied by a petty tyrant on a power trip. The first week of July, I got a notice that my account had been turned over to collections. I forwarded it to David, who sent a cease and desist letter to both the HOA and the collection agency. The letter laid out our position that the fines were invalid due to improper rule changes and discriminatory enforcement. On July 10th, 5 days before the board meeting where my appeal was supposedly going to be heard, David received the requested documents from the HOA. He called me that evening, and I could hear the excitement in his voice. "Mike, you need to come to my office tomorrow morning. I found something interesting." I was there at 8 the next morning with coffee for both of us. David had papers spread across his entire desk, sticky notes marking various pages. "Okay, so here is what I have discovered. The HOA sent me copies of the revised guidelines, board meeting minutes from April, and what they claim are the current bylaws. But when I went to the Maricopa County Recorder's office to pull the official recorded documents, something did not match up." "What do you mean?" "Every HOA in Arizona is required to record their bylaws and any amendments with the county recorder. It is part of the legal process of creating a homeowners association. The bylaws are a legal document that governs how the HOA operates, and they have to be on public record." "Okay." The Saguaro Heights HOA bylaws were originally recorded in 1998 when the development was built. I found that document. It is what you received when you bought your house. But here's the thing. I cannot find any recorded amendments, not from April of this year, not from any other time. According to the county records, the only official bylaws for your HOA are the original ones from 1998. I stared at him. "So the new rules do not actually exist?" "Legally speaking, no. They might have voted on them at a board meeting. They might have printed them out and started enforcing them. But if they were never properly recorded with the county, they are not valid. The only enforceable rules are the ones in the original bylaws." "How is that possible? How can an HOA board just make up rules?" "It happens more often than you would think. Most residents do not know the law. They assume that if the board says something is a rule, it must be legitimate. They pay the fines, follow the guidelines, and never question it. But here's the thing. Arizona law is very specific about this. HOA bylaws and amendments must be recorded to be enforceable. If they are not recorded, they are meaningless." "So what do we do?" David smiled. It was not a friendly smile. It was the smile of a lawyer who had just found the perfect weapon. "We go to that board meeting on the 15th, and we tear their case apart. And then we file a lawsuit for harassment, illegal fines, and emotional distress." The board meeting was held in the community clubhouse, a bland stucco building near the neighborhood entrance. I arrived with David at 7 in the evening. The room was set up with a long table at the front for the board members and rows of chairs for residents. About 20 people were scattered throughout the seating area. The board sat at the front table like judges at a trial. Patricia Holbrook was in the center, a woman in her early 50s with iron gray hair and a face that looked like it had forgotten how to smile. To her left was the vice president, a balding man named Roger Simmons. To her right was the treasurer, Karen Mitchell, a thin woman with too much makeup and a perpetual expression of disapproval. 2 other board members flanked them, neither of whom I recognized. Brenda sat at a small desk to the side, apparently serving as secretary. Patricia called the meeting to order with a sharp rap of her gavel. They went through standard business first, approving minutes from the last meeting, discussing the budget, and reviewing upcoming neighborhood events. Then, Patricia looked at a paper in front of her. "We have one appeal on the agenda this evening. Mr. Mike Carson is appealing a violation notice regarding a commercial vehicle parked in his driveway. Mr. Carson, would you like to address the board?" I stood up. David stood with me. "Yes, thank you. I received a violation notice in June claiming that my personal pickup truck is a commercial vehicle. I have owned this truck and parked it in my driveway since I bought my house 3 years ago. It has never been an issue before. I believe this violation is based on rules that do not exist in the original HOA bylaws." Patricia's expression hardened. "The board has updated the community guidelines to maintain property values and neighborhood aesthetics. Your vehicle is in violation of those guidelines." "Can you show me where in the recorded bylaws this rule exists?" David asked, his voice calm and professional. Patricia looked at him with irritation. "And who are you?" "David Chen. I'm Mr. Carson's attorney." A murmur went through the room. Patricia exchanged glances with the other board members. "The board does not need to justify its decisions to an attorney," she said. Actually, you do," David replied. Arizona law requires that HOA bylaws and any amendments be recorded with the county recorder's office to be legally enforceable. I have obtained copies of all recorded documents for this HOA from Maricopa County. The only bylaws on record are the original ones from 1998, which contain no restrictions on personal pickup trucks. Patricia's face flushed red. The board voted on updated guidelines in April. Voting on them at a board meeting does not make them legally valid. They must be recorded. Were these updated guidelines recorded with the county? Silence. Patricia looked at Brenda, who was suddenly very interested in her notepad. The board has the authority to establish community standards, Patricia said, her voice rising. Only within the framework of your recorded bylaws, David said. If you have made amendments to those bylaws, you are required by Arizona Revised Statute Section 33, 1808 to record them. If you have not recorded them, they are not enforceable. This is ridiculous, Karen Mitchell interjected. We are trying to maintain a beautiful neighborhood, and you are hiding behind technicalities. The law is not a technicality, David said. It is the law. And furthermore, even if your rule changes were valid, you would still be required to enforce them uniformly. My client has documented at least 11 other residents in this neighborhood with similar vehicles who have not received violations. That is selective enforcement, which is also illegal. Roger Simmons cleared his throat. Mr. Carson, perhaps we can come to a compromise. If you agree to park your vehicle in your garage instead of your driveway, we can waive the fines. No, I said. The word came out harder than I intended. I am not compromising on something I have every right to do. I park my truck in my driveway because I use my garage for my woodworking hobby. The original bylaws, the only legal bylaws, allow me to park personal vehicles in my driveway. I have done nothing wrong. Patricia stood up, her hands flat on the table. The board has made its decision. The violation stands. The fines stand. This meeting is adjourned. Then we will see you in court, David said. We filed the lawsuit 3 days later. The complaint laid out everything: the invalid rule changes, the selective enforcement, the harassment, and the attempted collection of illegal fines. We sued the HOA as an entity and also named Patricia Holbrook, Karen Mitchell, and Roger Simmons individually for abuse of authority. The reaction was immediate. Within a week, I received a certified letter from the HOA's attorney, a large firm in Phoenix. The letter claimed our lawsuit was frivolous and threatened to countersue for legal fees. David sent back a response that was essentially a polite version of "bring it on." Discovery began in August. David subpoenaed all board meeting minutes for the past 2 years, all financial records, all correspondence related to my violation, and all other violation notices issued in the same time period. The HOA fought us on almost every request, which only made them look worse. In September, we got a break. During a deposition, Brenda let something slip. David was questioning her about the process for recording bylaw amendments, and she said, "We were going to record them, but Patricia said it was too expensive and not necessary since we are just clarifying existing rules." David jumped on it. "So the board knowingly chose not to record the amendments?" Brenda realized her mistake too late. Did Patricia Holbrook specifically state that the amended guidelines should not be recorded with the county? I do not recall the exact words. But the damage was done. It was on the record. The board had known the rules needed to be recorded and had deliberately chosen not to do it. David also discovered something else interesting in the financial records. Over the past year, Patricia had authorized several payments to her own landscaping company for work in the common areas. The amounts were not huge, but they were significant. $10,000 here, $15,000 there. There was no evidence that the board had put the work out for competitive bids, which was required by the bylaws for any expense over $5,000. "She is basically embezzling HOA funds," I said when David showed me the records. "It is not quite embezzling, but it is definitely a conflict of interest and a violation of fiduciary duty. She is supposed to act in the best interest of the HOA, not use her position to funnel money to her own business." "Can we use this?" "Absolutely. It goes to show a pattern of the board ignoring their own bylaws and operating however they want." In October, the HOA's attorney reached out about a potential settlement. They offered to drop all fines against me and to agree not to enforce the vehicle rules going forward. In exchange, I would drop the lawsuit and sign a non-disclosure agreement. I was ready to tell them where they could shove their settlement, but David advised me to think about it. Look, I know you want to fight this on principle, and I respect that. But litigation is expensive and stressful. Even though I think we have a strong case, there's always risk in going to trial. This settlement would give you what you want. No fines, no restrictions on your truck. But it lets them get away with everything. The illegal rules, the harassment, the conflict of interest. They will just do the same thing to someone else. That is true. But at some point, you have to weigh the cost of fighting against what you will actually gain. You would be spending thousands more in legal fees to pursue a case that, at best, will get you some monetary damages and force the board to follow proper procedures. It will not change the fact that HOAs have a lot of power and that some people abuse that power. I thought about it for a long time. David was right that it was costing me money and stress, but every time I considered settling, I thought about Patricia's smug face at that board meeting. I thought about how she had targeted me for speaking my mind at a community meeting. I thought about how many other residents she had probably bullied over the years, people who did not have the resources to fight back. No settlement, I told David. We go to trial. He grinned. I was hoping you would say that. Trial was scheduled for February 2025. In the months leading up to it, the neighborhood dynamics became increasingly hostile. Patricia and her allies on the board started finding violations everywhere they looked. Tom across the street got cited for having his trash cans visible from the street, even though it was trash day. The Johnsons got a notice about their lawn being a quarter-inch too long. A family at the end of the block got fined for having a wreath on their door that was not on the approved decoration list. But something unexpected happened. Instead of intimidating people into compliance, Patricia's tactics backfired. Residents started talking to each other. They realized that the board was out of control. A group of homeowners, led by a retired paralegal named Susan Rodriguez, started organizing. They came to me and asked about the lawsuit. If you are fighting them on the bylaws never being recorded, does that mean all their new rules are invalid? Susan asked. According to my attorney, yes. So all these fines they have been issuing over the past year, none of them are legitimate? That is what we are arguing in court, Susan smiled. I think it is time for a recall election. Under the HOA's original bylaws, the ones that were actually recorded and legal, residents could petition for a special election to recall board members. It required signatures from 20% of homeowners. Susan and her group collected signatures for 2 weeks. They got signatures from 40% of the neighborhood. Patricia tried to block the recall election, claiming the petition was improperly formatted. Susan, with advice from David, filed a motion with the court. The judge ordered the HOA to hold the election. The recall vote took place in January 2025, 1 month before our trial date. All 5 board members were up for recall. The meeting was packed. Over 100 residents showed up, far more than had ever attended a regular board meeting. The anger in the room was palpable. Patricia tried to maintain control, but residents were not having it. One after another, people stood up to speak. They talked about arbitrary fines, about rules that kept changing, about feeling harassed in their own homes. One elderly man broke down crying as he described how the board had fined him $3,000 for having dead patches in his lawn, even though he was on a fixed income and struggling to afford basic maintenance. When the vote was tallied, it was not even close. All 5 board members were recalled by margins of over 70%. Susan Rodriguez was elected as the new board president. Her first act was to suspend all fines issued under the unenforced rules. Her second act was to hire a new management company to replace Brenda and her office. With the board replaced, the HOA's attorney withdrew from the case. The HOA, now under new leadership, had no interest in defending the actions of the previous board. But that did not mean we were done. David and I had also sued Patricia, Karen, and Roger individually, and that case was still going forward. The trial began on February 3rd. It was held in Maricopa County Superior Court in downtown Phoenix. Judge Sarah Martinez presided. She was a no-nonsense woman in her 60s with a reputation for not tolerating games from either side. David laid out our case methodically. He presented the original recorded bylaws. He presented the unrecorded revised guidelines. He brought in an expert witness, a real estate attorney who specialized in HOA law, who testified that unrecorded amendments were not legally enforceable in Arizona. He showed the evidence of selective enforcement with photos and documentation of other trucks in the neighborhood that had never been cited. He presented Brenda's deposition, where she admitted the board had chosen not to record the amendments. Then, he got into the financial records. He showed the payments to Patricia's landscaping company. He showed that the bylaws required competitive bidding for any work over $5,000, and that no such bidding had occurred. He calculated that over 18 months, Patricia's company had received approximately $87,000 from the HOA. The attorney representing Patricia, Karen, and Roger tried to argue that the board had acted in good faith, that they believed they had the authority to update guidelines without recording them, and that the payments to Patricia's company were legitimate because her prices were competitive. David destroyed those arguments on cross-examination. He got Patricia to admit on the stand that she knew bylaw amendments were supposed to be recorded, but had decided it was not necessary. He got her to admit that she had specifically targeted me for enforcement after I opposed the speed bump proposal. He got her to admit that she had never obtained competitive bids before hiring her own company. The trial lasted 4 days. Judge Martinez took another week to issue her ruling. We won on every count. The judge found that the revised guidelines were not legally enforceable because they had not been recorded. She found that the board had engaged in selective enforcement constituting harassment. She found that Patricia had breached her fiduciary duty through self-dealing with the landscaping contracts. The damages were substantial. The judge awarded me $25,000 for emotional distress and attorney's fees. She ordered Patricia, Karen, and Roger to personally reimburse the HOA for the money paid to Patricia's landscaping company, plus interest. She issued an injunction prohibiting any of them from serving on the HOA board in the future, but the story did not end there. Susan Rodriguez, as the new board president, reviewed all the financial records in detail. She found more irregularities. Patricia had also been paying herself a monthly stipend as board president, something that was not authorized in the bylaws. Over 3 years, she had paid herself approximately $36,000. Susan filed a complaint with the Arizona Attorney General's office. The AG's office opened an investigation into potential fraud. In May 2025, Patricia Holbrook was charged with theft and fraud for misappropriation of HOA funds. Karen Mitchell and Roger Simmons were charged as accessories for knowingly approving the fraudulent payments. The criminal trial took place in October 2025. I attended every day, sitting in the gallery and watching as prosecutors laid out a pattern of corruption and abuse. Patricia's attorney tried to argue that she had provided legitimate services to the HOA and that the payments were not theft. But the prosecution showed that she had systematically violated the bylaws, failed to obtain proper approval for expenses, and used her position to enrich herself at the expense of her neighbors. The jury deliberated for 6 hours. They found Patricia guilty on 4 counts of fraud and 2 counts of theft. Karen and Roger were convicted as accessories. Patricia was sentenced to 18 months in prison and ordered to pay full restitution of all funds, which totaled over $120,000. Karen and Roger received probation and were ordered to pay their share of the restitution. As I sat in the courtroom and watched Patricia being led away in handcuffs, I felt a strange mix of emotions. There was satisfaction, certainly. Justice had been served. But there was also sadness. This was a woman who had been given a position of trust and responsibility in her community, and she had abused it so thoroughly that she was now going to prison. After the sentencing, Susan Rodriguez approached me outside the courthouse. "Mike, I want to thank you. If you had not stood up to them, none of this would have come to light. Patricia would still be on the board, still stealing from the HOA, still making everyone's lives miserable." "I just did not want to pay a bogus fine," I said. "You did a lot more than that. You showed people that they do not have to accept abuse from petty tyrants. You reminded everyone that the law applies to HOA boards, too." The new board under Susan's leadership was like night and day compared to Patricia's regime. They scheduled regular meetings with proper notice. They posted all financials online for residents to review. They put all major expenses out for competitive bids. They even held a community vote before making any changes to the bylaws, and when changes were approved, they were properly recorded with the county. The atmosphere in the neighborhood changed too. People stopped living in fear of orange envelopes on their windshields. Kids played in the streets again without their parents worrying about noise complaints. Neighbors talked to each other instead of reporting each other. I still live in that house in Scottsdale. I still park my Toyota Tacoma in my driveway. And every time I walk past it, I remember that standing up for yourself, even when it is difficult and expensive and stressful, is worth it. Because the alternative is living under the thumb of someone who has convinced themselves that a little bit of power gives them the right to control other people's lives. And once you let that happen, once you accept that kind of abuse as normal, it only gets worse. My case became something of a landmark in HOA law in Arizona. David wrote an article about it that was published in a legal journal. Other attorneys started using our case as precedent in similar disputes. The Arizona legislature even introduced a bill to strengthen the recording requirements for HOA bylaws and to increase penalties for board members who violated their fiduciary duties. Tom across the street still jokes that I turned a $500 fine into a federal case. He is not wrong. But sometimes a $500 fine is not really about $500. Sometimes it is about whether you are going to let someone bully you in your own home. A year after Patricia's sentencing, Susan Rodriguez knocked on my door. She had a proposal. The HOA wanted to commission a plaque to be installed at the community clubhouse. It would list the rights of homeowners and the responsibilities of the board, a permanent reminder of what had happened and why it must never happen again. "We want to call it the Carson Resolution," Susan said, "if that is okay with you." I was not sure how I felt about having my name on something like that. It seemed grandiose. But Susan explained that it was not about me personally. It was about the principle. It was about making sure that future residents, people who moved into the neighborhood 10 or 20 years from now, would know that their rights mattered. I agreed, and the plaque was installed in March 2026. It is a simple bronze rectangle mounted on the wall just inside the clubhouse entrance. It lists the fundamental rights of homeowners, the right to use their property within legal guidelines, the right to due process before fines are imposed, the right to access HOA records, the right to recall board members who abuse their authority. At the bottom, it says, "In recognition of the residents who stood up for these principles when they were threatened." My attorney, David Chen, ended up specializing in HOA law after our case. He told me that he gets calls every week from homeowners dealing with similar situations. Some of them are legitimate disputes over property maintenance, but many of them, too many of them, are cases of board members abusing their power. The problem is that HOA boards attract a certain type of person, David told me over lunch one day. People who want power and control but do not want to go through the trouble of actually getting elected to real government positions. They see an HOA board as a way to be in charge of something, to tell people what to do. And when you give someone like that even a little bit of authority with no real oversight, bad things happen. So what is the solution? More transparency, more accountability, state laws that make it easier for homeowners to challenge bad boards and harder for boards to operate in secret, and honestly, more people like you who are willing to fight back instead of just paying the fine and moving on. I thought about that a lot. How many people had Patricia fined over the years before she targeted me? How many of them had just paid because it was easier than fighting? How much money had she collected through invalid fines, money that had gone into the HOA's coffers and eventually into her own pocket through her landscaping contracts? The ripple effects of the case continued for years. 2 other HOAs in Scottsdale were investigated after residents used our case as a template to examine their own board's activities. One of those boards was found to have similar issues with unrecorded bylaw changes. The other had a treasurer who had been skimming money for nearly 5 years. The publicity also led to changes in how HOA management companies operated. Brenda's company, the one that had been managing Saguaro Heights, lost most of their clients after the trial. It turned out that they had a pattern of helping boards push through questionable rules without proper procedures. They went out of business in late 2025. As for me, I became an accidental activist. I started getting invitations to speak at community meetings in other neighborhoods. People wanted to hear the story, wanted to know how I had fought back, wanted advice on dealing with their own problem boards. I always told them the same thing. Document everything, know your rights, and do not be afraid to get an attorney involved if you need to. HOA boards rely on residents being intimidated and uninformed. Once you shine a light on what they are doing, once you force them to follow their own rules, they usually crumble pretty quickly. One of the most satisfying moments came about 2 years after the initial violation notice. I was at a neighborhood barbecue, one of the regular community events that the new board had started organizing to actually bring people together instead of just issuing fines. Tom came over with a beer for me. "You know what I was just thinking about?" he said. "Remember when Patricia tried to fine you for your truck? Remember how stressed you were? Yeah, that was a rough time. But you did not back down. You could have just parked in your garage or sold the truck or paid the fines. You could have made it easy on yourself, but you did not." I was stubborn. "You were right, and because you were stubborn, all of us are better off. My kids can play basketball in the driveway without worrying about noise complaints. I can plant the flowers I want in my yard instead of only the approved species. We actually know where our HOA fees are going because the board has to be transparent now. All of that happened because you would not pay a bogus $500 fine." I clinked my beer against his. "To stubbornness. To standing up for what is right," he corrected. The criminal case against Patricia, Karen, and Roger also had a deterrent effect. News of HOA board members actually going to prison for fraud made headlines locally and even got picked up by some national news outlets. Suddenly, people serving on HOA boards across Arizona, across the country really, were a lot more careful about following proper procedures and avoiding conflicts of interest. David told me that in his practice he had seen a noticeable shift. Boards were more willing to settle disputes reasonably instead of digging in and fighting. Management companies were more careful about advising boards to follow the law. Homeowners were more willing to speak up when something seemed wrong. "You changed the culture," David said. "Not completely, obviously. There are still bad boards and abusive management companies. But you made it a little bit harder for them to get away with it." In 2026, I was invited to testify before an Arizona legislative committee that was considering reforms to HOA laws. I talked about my experience, about the invalid bylaws and the selective enforcement and the corruption we had uncovered. I talked about how the law as it existed was not really protecting homeowners from bad boards. The committee listened, asked questions, and took notes. 6 months later, they passed a comprehensive reform bill. It strengthened the requirements for recording bylaw changes. It created a state-level HOA ombudsman office to help resolve disputes. It imposed mandatory training for board members on their legal responsibilities. And it increased penalties for board members who violated their fiduciary duties, making it easier to prosecute cases like Patricia's. The governor signed it into law in December 2026. When the bill was signed, Susan Rodriguez called to tell me that she had been invited to the signing ceremony, and she asked if I wanted to come along. I stood in the state capitol building and watched the governor sign the bill surrounded by legislators and homeowner advocates. It was a surreal moment. 3 years earlier, I had been standing in my driveway, staring at an orange envelope, angry about a stupid fine. Now I was watching state law change partly because of what had happened. After the ceremony, one of the legislators approached me. "Mr. Carson, I want to thank you for your testimony. Your case really illustrated the problems we were trying to address with this legislation." "I just did not want to pay a fine I did not owe," I said. She smiled. "Sometimes the biggest changes start with someone simply standing up for themselves. You would be surprised how rare that is." Looking back on everything that happened, from that first orange envelope to the criminal convictions to the legislative reforms, I am struck by how easily it could have gone differently. If I had just paid the fine, if I had moved my truck, if I had decided that fighting was not worth the hassle, none of it would have happened. Patricia would still be on the board, still embezzling money, still making residents miserable. The invalid bylaws would still be enforced. Karen and Roger would still be enabling the corruption, and hundreds of homeowners would still be living in fear of arbitrary fines and harassment. But I did not pay the fine. I got angry instead, and then I got a lawyer. And then I got justice. My life now is pretty much back to normal. I work as an engineer for a tech company. I do woodworking in my garage on weekends. I go hiking in the mountains. I have dinner with my neighbors. I park my truck in my driveway. The only real difference is that I pay a lot more attention to community governance now. I attend HOA meetings regularly. I vote in board elections. I review the financial reports when they are posted. Because I learned the hard way that the price of freedom, even the small domestic freedom of parking your truck in your own driveway, is eternal vigilance. People sometimes ask me if I regret not taking the settlement offer, the one where the HOA would have dropped the fines in exchange for me dropping the lawsuit. I tell them no. The settlement would have solved my personal problem, but it would not have addressed the systemic issues. Patricia would have continued to abuse her power. Other residents would have continued to suffer. The corruption would have continued. By fighting it all the way through, by exposing what was really happening, we fixed something bigger than just my fine. We fixed a broken system. We held corrupt officials accountable. We changed the law to protect future homeowners. Was it stressful? Absolutely. Did it cost me money even with the damages award? Yes. Was it worth it? Every single day. Because now when I pull into my driveway and see my truck sitting there, I do not just see a vehicle. I see a symbol, a reminder that ordinary people can fight powerful institutions and win. A reminder that the law is supposed to protect everyone, not just those with authority. A reminder that sometimes the most important thing you can do is simply refuse to be bullied. Tom still teases me about it. He calls me the neighborhood folk hero, which is embarrassing but also kind of funny. Other neighbors have started coming to me for advice when they have disputes with any kind of bureaucracy, not just the HOA. I have helped people fight unfair parking tickets, challenge property tax assessments, and dispute charges from contractors. I'm not an expert on any of this stuff. I just learned through my own experience that you have rights, and sometimes you have to insist on those rights even when it is inconvenient. Susan Rodriguez served 2 terms as HOA president before stepping down to spend more time with her grandchildren. Under her leadership, the HOA became a model for how these organizations should operate. Transparent finances, fair enforcement of reasonable rules, regular communication with residents, and a focus on actually building community instead of just issuing citations. The new board even did something radical. They reduced the HOA fees. It turned out that without Patricia's landscaping company charging inflated prices, without the legal fees from fighting bogus lawsuits, and without board members paying themselves unauthorized stipends, the HOA did not need as much money. Fees dropped by 30%. David Chen and I stayed in touch. He sent me a bottle of good whiskey every year on the anniversary of the verdict. We would get together, have a drink, and talk about how the case had affected both our lives. He built a successful practice largely on HOA cases. I became a more engaged citizen, not just in my HOA, but in local government generally. You know what the real lesson is? David said one evening as we sat on my back patio watching the sunset over the mountains. It is that the system works, but only if people use it. You had to hire an attorney. You had to spend money and time. You had to go to court. But in the end, the law protected you. The bad actors were punished, justice was served. That would not have happened if you had just accepted the injustice. He was right. The system had worked, but it had only worked because I had insisted on it. That is both the strength and the weakness of our legal system. It provides powerful tools for justice, but you have to be willing to pick up those tools and use them. I often wonder about the other residents who were fined by Patricia over the years before I came along. People who paid fines for grass that was supposedly too long, or decorations that were not approved, or vehicles that violated made-up rules. How much money did they collectively lose? How much stress and anxiety did they endure? How many of them felt violated in their own homes, but did not know they could fight back? That is why I say yes whenever someone asks me to speak about my experience. That is why I agreed to let Susan put up that plaque. That is why I testified before the legislature. Because if my story can inspire even one person to stand up against an abusive HOA board, to demand their rights, to insist on proper procedure and fair treatment, then all the stress and expense was worth it. The neighborhood feels different now. People wave to each other. Kids ride bikes in the streets. Residents actually decorate for holidays without fear. The community events are well attended and genuinely fun. It feels like a real neighborhood, not a prison where inmates nervously watch for guards. And my truck still sits in my driveway every night, exactly where it belongs. No orange envelopes, no threatening letters, no bogus fines. Just a regular pickup truck in a regular driveway, owned by a regular guy who got tired of being pushed around. Sometimes the most radical act is simply refusing to comply with an unjust rule. Sometimes standing up for yourself means standing up for everyone. And sometimes a fight about where you park your truck is really a fight about fundamental principles of fairness, accountability, and the rule of law. I did not set out to be a crusader for HOA reform. I just wanted to park my truck in my driveway without being harassed. But life has a way of pushing us into roles we never expected. The question is whether we rise to the occasion or shrink from it. I am glad I rose to it. I am glad I fought back. I am glad I exposed the corruption and changed the system. Because now, every time I come home and see my truck in the driveway, I do not just see a vehicle, I see victory.